Now I am going to dictate a legal passage on Supreme Court latest judgment at the rate of 100 words per minute. Let's start. The appellant Anil Kumar has been convicted under sections 302 and 498A of the Indian Penal Code 1 by both the courts below and has been sentenced to life imprisonment and to pay fine of rupees 50,000 and in default to undergo simple imprisonment for 1 year under section 302 IPC and rigorous imprisonment of 1 year under section 498A IPC with direction that both the sentences would run concurrently. Stop para. The incident is of 26/09/2010 and had taken place at 9 a.m. in the morning at the house of the appellant. The allegation is that the appellant, with the intention to kill his wife, lighted a matchstick and threw it upon her when she had already poured kerosene upon herself due to the quarrel with the appellant. Stop para. The FIR number 621/2010 dated 26/09/2010 was initially registered under section 307 IPC, wherein it has been stated that the deceased wife, due to unbearable mental and physical harassment caused to her by the appellant, poured kerosene upon herself to deter the appellant from causing further torture to her, and that the appellant, with the clear intention to kill her, took advantage of the situation and lighted the matchstick and threw it on her body, uttering "You die." Thus, the deceased wife has inflicted with burn injuries at their residence by the appellant with clear intention of killing her subsequently. When the deceased wife died in the hospital, the case was converted into that under sections 302 and 498A of IPC para. On the basis of the aforesaid FIR, the appellant was charged for auxiliary para. There is a clear and clinching evidence on record that the appellant used to harass the deceased wife by making demands for dowry and that both of them used to quarrel a lot. The marriage between the two was solemnized about 11 years before the date of incident, and from the wedlock they had a boy and a girl. At the time of the incident, their children were playing in the courtyard, and that the boy, though of a tender age, had deposed that appellant was in habit of beating his wife, and there used to be frequent quarrels between his parents. Para. In the trial court as well as before the High Court, the defense of the appellant was that he is not at all guilty of burning his wife. She had the suicidal tendency and had tried to immolate herself on one earlier occasion and had once even tried to cut her veins. She herself had poured kerosene upon herself and set herself on fire. The appellant had simply tried to douse the fire by pouring water from the bucket. Para. The defense so set up by the appellant was not accepted by either of the courts below in view of the overwhelming evidence on record regarding their frequent quarrel and the harassment meted out to the deceased wife. The ocular evidence of the witnesses clearly proved that on the date of the incident there was again a quarrel between both of them, though on a petty matter, but the deceased wife, in order to avoid torture at the hands of the appellant and to deter him, went inside the kitchen and poured kerosene on herself. Thereafter, the appellant took advantage of the situation and set her on fire. Para. We had heard the learned counsel for the parties. Para. Learned counsel for the appellant had argued that the appellant had no to kill her. Therefore, the provision of section 302 IPC are not applicable, and at best he can be charged under section 304 part 2 of IPC. Stop. Thank you.